Thing. July. Oh, my mic's on. Sorry, Judge.
Your Honor, I still can't hear you. I don't know if anybody else can. Sounds good. We'll be waiting.
No, you wouldn't have. No, Robin can't.
I can hear you guys now.
We can hear that.
Well, the old has-been has found the secret. We're good to go.
Thanks, Judge. I appreciate it. Judge McKeag has been gracious enough to stay here for today, and thank God. Actually, my name is Gary Cheney, and Judge McKeag's retiring, and hopefully he'll be around a lot more to help with all this COVID stuff. We're so backed up. He's graciously agreed to be a visiting judge when we need him, if we ever get things going again. That's part of our problem. But this is the second time we've done it, and it seemed kind of worked the last time, but we're just having issues today. So it's probably good. But and you're Mr. Silman?
I am, Your Honor.
You're not only the petitioner's attorney, you are the petitioner.
That's correct.
And Ms. Hill, I guess you're in for the defendants today?
Yes, I represent the defendants, Your Honor.
And Robin, can you hear me?
I can, yes, sir.
Okay, and let me check. Let me unmute. I don't know if they need to be on there. Okay, we're good with everybody else. Okay, with that said, I kind of got a lot going today, so I'm going to kind of get right to it. Let me go ahead and Robin, let's go ahead and put this on the record. This is cause number 19-06-25589. It's in the matter of Chad R. Silman, S-I-L-L-M-A-N, versus Keller Williams Platinum, P-L-A-T-I-N-U-M, Houston, Texas, et al. And no, there's a name issue that's kind of going on there, I see. But I've read the motion, and I guess if you'll introduce yourselves first for the record, Mr. Silman.
My name is Chad Silman, plaintiff and attorney for the plaintiff.
Okay, and Ms. Hill, would you?
Yes, Ms. Hill representing Ann Walker and Keller Williams Realty Greater Northwest and Monica Atkins. So that's the name issue. It's Keller Williams Realty Greater Northwest. There's two companies, so it's kind of confusing there, but that's the party to this case, Your Honor.
Gotcha. And one thing it's going to be hard for me. My court reporter I've known for 20-something years, 28 years, probably going close to 30 years. I am a fast talker. I've tried to stop that for many, many years, and I pretty much have given up on that. But so Robin, I always have to really take out to eat a lot because I abuse her regularly. But I'm going to try to be vigilant and talk slowly. But the other reason it's very important to do that, which I'm sure this isn't your first Zoom hearing, is that there's a delay. Okay, and so I'm trying to be real cognizant of that, even though I like to jump out there real quick. And if you guys would do that as well, it'd be really, really nice for Ms. Wiley. Okay? Okay, good. Let me do some housekeeping measures. Just explain, we're doing this via Zoom teleconference application due to the COVID virus. This hearing is also being broadcast live on the 506 YouTube channel. So with that, I guess Ms. Hill, it's your motion. If you'll go ahead and start.
Yes, Your Honor, thank you. So this is a motion for leave to replead under the Civil Practice and Remedies Code 33.004. This case involves the sale of an undeveloped property. In that undeveloped property, the plaintiff alleges that my clients, the broker and the agent, either misrepresented or failed to disclose that the property was either entirely or completely in a floodway, Your Honor. So that's the background for this case. We filed a motion for leave to designate the buyer's agent, Mr. Brian Winkler, back in October. And we sent that for submission. It was denied on November 9th, Your Honor. And so under the statute 33.004, before a motion for leave to designate a responsible third party is denied, the defendants are supposed to be allowed leave to replead sufficient facts to meet the fair notice pleading standard under the Texas rules. And so, Your Honor, what we're asking for here is leave to replead so that we can give those facts. And additionally, Your Honor, clear up, there's an issue with the statute of limitations here. Plaintiff filed their case 2 days before limitations came up. And in their response, they argued that because we designated outside of limitations, we couldn't designate, which is in the rules, but also, Your Honor, we want to show that the Texas Supreme Court recently decided a case which discussed this rule and the issue of the designation when it's outside limitations, but the plaintiff files very close to limitations. So in our motion for leave, we would describe that case, and it's a Texas Supreme Court case, In Re Mobile Mini Inc. And so that's what we're asking for leave for, to give more facts. We recently received plaintiff's discovery responses, so we have actual documents from Brian Winkler, and we have the ability to really allege more specifically and to show that our designation, even though outside limitations, was proper, Your Honor.
Mr. Stillman.
Yeah, thank you, Your Honor. This is a second motion, it appears to me, from the one Ms. Hill referenced from back in October. And plaintiff's objection then is, in my opinion, still relevant. While we admitted in the briefing of the first motion that a movement can make the motion to add a responsible third party after the statute of limitations is closed, it doesn't allow for a completely open-ended window for them to do so. And the facts that were briefed in that motion or briefing were that the defendant made their motion 1 year, 122 days after we filed the case. This case was filed in June of 2019. And it was a few days before the statute of limitations did expire. I guess that's the side effect of representing yourself. But the potential party that the defendant would like to have added as a responsible third party is not an obscure, hard to find party in the case. It was my real estate agent, and his name has been on every document, including the sales contract, from the very beginning. And it wasn't till over a year and several months that the defendant has engaged in the case. Ms. Hill has, on the record, has been great and very responsive to me while we've been prosecuting the case together. But prior to that, we've had 4 or more attorneys, lead attorneys at her firm, and they didn't ask for a discovery until well after a year after the case had started, and I had asked for discovery very early on in the process. So I guess I would just ask the court to be the mediator in this, in that this is not a Texas Supreme Court case where we've got a hard to find responsible third party. We're well past the statute of limitations. There were a number of opportunities to make Mr. Winkler a responsible third party, and it seems very much to me that this late in the game, we're trying to do that to spread the blame. So that would be my position, Your Honor.
Okay. Is that it from both sides?
Your Honor, I would like to briefly respond, if you don't mind. I would just add that he's correct that this party was known, and Mr. Silman could have sued him from the beginning, and he didn't. It was his buyer's agent. He owed fiduciary duties to the plaintiff, and he didn't bring them in the beginning. And I would also like to add that when we got the discovery responses from plaintiffs recently in October, we found another buyer's agent that we had no idea was even part of this transaction, a Mr. Stone. He wasn't listed on the contract or anything like that, Your Honor. So really, when we got those discovery responses, we found new facts about Brian Winkler and about this other agent, Your Honor. And so we're asking just to designate him as responsible third party. That doesn't mean he is automatically has any liability attached to his name in the jury charts. It's just so that we, in trial, in front of the trier of fact, would have to put on evidence that Brian Winkler owed a duty to the plaintiff and had responsibilities and failed to comply with those, Your Honor. So that's what we're asking here. Leave to show you those facts and to show that our designation outside limitations was proper because of the Supreme Court's ruling and the fact that there's no prejudice to plaintiffs here for our designation, since plaintiffs knew about their buyer's agent's potential fault from the beginning, Your Honor.
Okay. Not only do I have a new computer, we're in a new courthouse. And so I don't move around enough, the lights go out. So we got to fix that too. So, because I've lived my whole life in the dark, I don't want to have to work as a Mr. Silman, I pretty much made up my mind. Do you have anything else you need to say? Or
No, Your Honor.
Okay, I've read the pleadings, I've looked at the law, and I've listened to your argument, and I'm going to rule, for the defendant, I'm going to grant the motion to replead. I need you to replead by on or before January 22nd. And I'll put that in the order and sign it, and then it'll go to the clerk's office. I'm just going to use your order and just scratch on there, due by the 22nd.
All
Okay?
right, thank you, Your Honor.
All right. Did y'all have anything
Thank
else?
you.
No, Your
No,
Honor.
Your Honor.
Okay, court's adjourned. Thank you.
Thank you.
Bye-bye.